Outgoing Chief Justice Ian-Chang came out of his pre-retirement leave last Friday and ruled that Citizenship Minister Winston Felix and the Minister within the Ministry of Social Protection Keith Scott cannot sit as technocratic ministers in the National Assembly. The Attorney General believes the ruling is flawed.
We reject that decision as being erroneous in point of law, and we are going to challenge that decision. The decision, from what I've been able to garner from it, is that the Chief Justice is saying he wouldn't make any coercive order against the Speaker of the National Assembly, but he expects that the Speaker of the National Assembly would follow his ruling or etc.
The Attorney General is questioning the move by Chief Justice Chang, noting that the CJ came out of his pre-retirement leave to make a decision on a political matter which only one party had the opportunity to be heard.
I want to say that was so surprising, and it's improper really to treat the Attorney General chambers in that manner by just suddenly out of the blues surfacing to say you're rendering a decision without giving the Attorney General the opportunity to be heard in the first place, because the matter was not completed by the Chief Justice before he went on leave, because I was not allowed an opportunity to respond to the submissions given by Nandalal.
In July 2015, a People's Progressive Party member Dennis Morian filed a constitutional motion seeking legal intervention to remove Ministers Scott and Felix from the National Assembly. Former Attorney General Anil Nandlal, who represented Morian, argued that the APNU AFC parliamentarians had been appointed in an unconstitutional and unlawful way. But, according to Attorney General Basil Williams, the learned Chief Justice had failed to address his mind to Section 98 of the Representation of the People's Act.
So it meant that this being provided in the Constitution, the Parliament then subsequently made that provision in the Representation of the People's Act, Chapter 103. And in Section 98 of that Act, it says this. It provides inter alia that when seats have been allocated to any list of candidates, the representative or deputy representative of such list shall extract from the said list as many names belonging to candidates selected by him for the purpose as can be so extracted without their number exceeding the number of seats allocated to that list.
The opposition People's Progressive Party in a statement on Monday said the party views the ruling as a triumphant of justice for the Guyanese electorate and looks forward with great anticipation to the commencement of the proceedings on the substantive elections petition. The Attorney General has the option to appeal the decision and file a stay of execution. Royden James, HGP Nightly News.